So the Department of Employment and Labour has gazetted its Code of Good Practice aimed at eliminating harassment at South African workplaces. Some of the specific examples of harassment highlighted in the code include sarcasm, facial expressions and gossip, just to name a few. We're joined now by Labour lawyer, Mr. Puke Maserumule. Thank you very much, sir, for availing yourself this afternoon. Let's perhaps start with what the department deals or terms harassment. How do they deal with that?
Good afternoon. Harassment is pretty widely defined. It includes what typically has been accepted as harassment, which is sexual harassment. But what the department has done is to extend that notion to include racial harassment, for example, to include ethnic harassment, harassment based on your origin. So the grounds of harassment are much wider than they used to be under the previous code, which was limited primarily to harassment, which was linked to racial discrimination or discrimination on the basis of gender. So under the new code, there's a lot of conduct which is prohibited, like you're saying. It starts from eye contact to actual physical acts of violence, as long as there is a connection between that conduct and either racism, gender, or religion, or any other ground which is prohibited as a ground for discrimination.
The first bullet point of unwanted conduct which impairs dignity is quite open to interpretation, according to my very simple understanding, at least, with some of, these points that they deal with for harassment. In terms of proving this, right, where it's your word against mine, how big of a difficulty do you perceive we'll see going into the future?
There will be, but it's really not different from the current position, because when harassment occurs, 9 out of 10 times it occurs in private. There are no witnesses. It's a line manager calling a junior into his or her office and saying things or touching, whatever the case may be. So it's always been my word against yours when it comes to harassment. At least most types of harassment. It's obviously different if it's harassment in the form of electronic communication, for example. If I send you a text message, a WhatsApp, now it's easy to produce the evidence because the definition has been extended to include that kind of conduct. Or perhaps if it occurs in the presence of other people, then there will be witnesses. But most forms of harassment, particularly of a sexual nature, tend to happen away from the public eye, if you like, and someone who has to make a decision whether or not there's been harassment has to weigh up the version of the complainant against that of the alleged perpetrator and determine whether the probabilities favor with the version of one or the other. But as I say, with text and things like that, it may be a little bit easier to prove the harassment.
What about this example of harassment, surveillance of an employee without their knowledge and with harmful intent? An employer can simply say, well, I just wanted to keep record in terms of, your timekeeping, just as part of your KPIs, if you have, to say you'll be on time. This is what your contract outlines for when you're supposed to be at work and when you're supposed to leave. So if I then feel that I am harassed because there's surveillance of an employee without their knowledge.
Well, the first point is what you're making is if I put in place measures to address timekeeping, for example, and I'm making use of cameras, then I have to tell the employees that you will be monitored and the monitoring will take the following effect. Because as you can imagine, if I put cameras in the change room, in the female change room, for example, and the cameras are monitored by male security guards, that would infringe on the dignity of the female employees. So whilst the intention may be to monitor timekeeping, how you do it becomes important. So employers will not be precluded from monitoring what employees do. It's simply how you do it that matters. You can't do it in a manner that may give rise to acts of harassment by your other employees, for example, those who monitor the cameras the security guards who have to search you when you enter the premises. All of those things can be done, but they have to be done in line and within the ambit of the law. So the employer's powers are not really taken away. It's the manner in which the power is exercised that is being regulated by the code.
Passive aggressive or covert harassment that the Gazette looks at, negative gossip, negative joking at someone's expense, sarcasm, condescending eye contact, and facial expressions. I thought that was quite interesting. How do you prove that just by merely looking at me? I could argue that it's not me, it's just my face.
Well, true, but I think the context matters. And I think what the code is aiming at is to deal with those subtle forms of harassment which people tend to be able to get away with. So, people making eyes at somebody else, particularly as between male and female colleagues, or it could be, depending on your preference, could be between females or males, as the case may be. But I think the idea is to eliminate any conduct which makes somebody else at the workplace feels threatened, feels inadequate, feels harassed in one or the other. And as you say, sarcasm can be more damaging than if I were to tell you to your face that I think you're ugly. You might, I've always known it, or I thought so. But if I say something in a sarcastic way, which conveys that view that I hold about you, and you sort of have a doubt as to whether that's what I meant or didn't mean, you could go around for a whole week or 2 weeks being unproductive because you're trying to figure out what it meant. And if it was intended to harass you, probably that's succeeding because now you are no longer comfortable at the workplace. So the idea is to ensure that the employees at the workplace, amongst themselves, and when they deal with others, clients, members of the public, that they don't make eyes at people, that they don't use sarcastic language which has either sexual or racial undertones, and that they don't use any other kind of conduct which may negatively impact on the dignity of the other person. And I think what the department is trying to do really is protect fellow employees as much as possible. In fact, if you look at the code, it talks about vertical and horizontal harassment, where horizontal harassment is you and I are colleagues and I harass you. With two colleagues, equal footing. But vertical, where I'm your line manager, you are my subordinate, and I use my authority and power to harass you either through language or conduct. So it's a far-reaching code. As you say, it may be difficult to completely enforce it because of the nature of the conduct that it's attempting to regulate. But I'm sure you'll appreciate that in a country such as ours, particularly where there's so much gender-based violence, that happens at the workplace as well. People are harassed at the workplace. And I think if you eliminate it there, at least you're taking one more step in fighting a monster that we have.
Employers can fall foul of the code through a number of actions, including spreading rumors maliciously. So those water cooler conversations, employees need to be aware?
Employees need to be aware. The fact that rumor mongering it's prohibited as a form of harassment if it's got either racial, ethnic, sexual undertones. It's part of the process because, again, workplaces can get very poisonous because of what happens in various corners of a workplace. In fact, I think similar to what you've said is a prohibition against effectively forming cliques at the workplace which excludes others, but does so on the basis of either their ethnic origin or sexual orientation or racial origin or ethnic origin. So the code really tries to cover as much ground as possible. It may well be criticized for that, for trying to do too much, and instead of being more broad and allowing for tribunals and courts to be more creative in how they interpret it. But I guess Parliament is there to make laws, and the minister is there to make regulations and codes of good practice, so that what the courts and the tribunals like the CCMA actually enforce is set out in pretty clear terms in the code, leaving very little room for somebody to say, I didn't understand my conduct to be a form of sexual harassment or racial harassment or some other kind of harassment.
If you have employed a domestic worker, you are now required to protect them from condescending eye contact, including by visitors. So as we go to celebrate Human Rights Day, according to your observation, do you perceive that South Africans are well versed with their rights?
Absolutely not. I think trying to get people to understand what their rights are is a process that involves a whole lot of education. I don't think that there's enough being done. I think the fact that this code was published on Friday the 18th, 3 days before Human Rights Day, it's intentional, clearly intended to make a contribution towards making people aware of their human rights. But as a matter of interest, the department does that, but if you go onto the department's website and try and access the code, you probably won't find it. So it's all about getting the message out there so that people know what rights they have, and that information must be easily accessible. What the code does is to then require employers to bring these matters to the attention of their employees so that the employees know that they have rights and that they can exercise those rights. But you and I know that employees are vulnerable. In a household, if you're a domestic worker, the likelihood of the domestic taking up the employer because a visitor made eyes at her is pretty small. It's worse where South Africans tend to employ people either illegally or do not pay them in accordance with the law, exploit them for those reasons, and people stay because they're desperate for work. So it's unlikely that people are going to be exercising their rights simply because the code has been published. I think there's a need for education, but I think there's also a need for enforcement. In other words, people need to know I can go to the CCM and take up my employer if this happens, and I can be protected. It's easier in a bigger workplace, much more difficult in a household or in a small company.
Just finally for us, there's also another example highlighted in the code in terms of harassment: withholding work-related information or supplying incorrect information. I mean, with something like this, how do you prove it outside of somebody saying, I genuinely forgot to include you in this email just this morning, having a case where, it's just a matter of oversight. I wanted to send it to you, but I actually sent it to somebody else. A simple mistake like that could actually cost you?
Well, you still have to produce the evidence to prove on a balance of probabilities that this had the effect of either harassing you or disadvantaging you. But I think the idea behind it is, people can, for example, be deprived of opportunities to apply for positions because an email about a vacancy is sent out 2 minutes, a few minutes before the applications must be submitted, or because I know you are working out of town and you may not be able to have access, and I'm doing it maliciously with that intent. Those are the kind of situations which will be covered. But whether we'll be able to prove that in a particular circumstance the intention was to deprive the other person of the opportunity to apply, for example, will always remain a matter of evidence proven on a balance of probabilities. And believe me, even though there will be deniers left, right, and center, it's not always impossible to prove that when you take all the circumstances together and you consider them, it seems more likely that this was intentional than unintentional. But it's a matter of how you assess the evidence that is before you once the matter gets to a tribunal like the CCMA or the Labour Court.
Labour lawyer Mr. Puke Maserumule, thank you very much for helping us make sense of this latest gazette by the Department of Employment and Labour, the Code of Good Practice aimed at eliminating harassment at South African workplaces.